The autonomy principle might also justify the non-compatibility of other dispute settlement mechanisms which the EU and its member states accepted, concluded. I'm referring here to the WTO dispute settlement mechanism and the dispute settlement system mechanisms negotiated under recent EU free trade agreements. From my point of view, the answer here is negative. There is no incompatibility with EU law. In Achmea, the court carefully specified that, and I quote, an international agreement providing for the establishment of a court responsible for the interpretation of its provision and whose decisions are binding on the institutions, including the Court of Justice, is not in principle incompatible with EU law. This is recital 57. Indeed, the competence of the EU in the field of international relations and its capacity to conclude international agreements necessarily entails the power to submit to the decisions of a court which is created or designated by such agreements as regards the interpretation and application of their provisions, provided that the autonomy of the EU and its legal order is respected. That is what the court said again in Achmea. When it comes to the WTO dispute settlement, the latter condition is fully respected, as the ECJ does not give direct effect to the DSB decisions. This case law, therefore, gives room for maneuver to the EU institution, makes possible political choice, even not to comply with those decisions. The state-to-state dispute settlement situation is, from my point of view, totally different from ISDS, from investor-state dispute settlement.